This is the lecture for week 6 of Law and Bioethics, in which we discuss third-party decision-making, including advanced directives, healthcare proxies, and surrogates. The objectives of this lecture are threefold: to review the laws surrounding third-party decision-making, including capacity, advanced directives, and surrogacy, to examine special challenges in agent-based decision-making, such as bad faith agents and conflicts of interest, and to review the ongoing controversy over one specific kind of advance directive, psychiatric advance directives. I do urge all of you to read the 1 to 2 page synopsis of the course materials for this week prior to watching the lecture or reading the cases, as I think it will give a good oversight of the material. Some terminology will be helpful for us. Capacity refers to the ability or inability of patients to make a specific medical decision. It is specific, so one might have capacity to accept a blood transfusion, but not have capacity to turn down gallbladder removal. It is a decision made by doctors. There's actually a case in New York State which says that unless a doctor is consulted, a healthcare proxy doesn't have authority to make decisions in the field before a patient has been determined to lack capacity. So in the case of Stein versus Nassau County, the patient was found down in the field, and the paramedics refused to honor a request of the patient's wife, who was his decision maker, because there was question as to whether or not he had been declared to lack capacity by a medical team or whether a physician had been consulted. And the second question, or the second term that you should be familiar with, is competence. Competence is a global decision. It refers to the global ability or inability to make all decisions, sometimes limited to all medical decisions or all financial decisions, but not decision specific. And it is decided by courts. It is a legal decision. Often when a patient is declared incompetent, a conservator or guardian is appointed. Those terms are used interchangeably in some states like New York, but differently in other states with slightly different roles. You may be familiar with the issue of guardianship in relation to the singer Britney Spears, whose guardianship case has been in the news. There are two different approaches to capacity that at least you should be conceptually familiar with. Both date from the 1970s and 1980s. The first is associated with the psychiatrist Paul Applebaum and the psychologist Thomas Grizzo, who wrote an article on capacity in the New England Journal of Medicine that I have included in the resource section that outlines 4 principles that a patient has to demonstrate to show capacity. First, they need to express a clear, consistent decision. So if they roll you down to the OR and you agree to have a surgery, and then you get there and you're scared by the equipment and you change your mind and they roll you back upstairs and the surgeon comes and talks to you and they roll you back down again, by the third or fourth time they've rolled you down, you've lost your capacity to make this decision. And secondly, you need to understand what the doctors think is wrong with you. Thirdly, you need to understand the risks and benefits of each proposed intervention and of doing nothing. And finally, there's a catch-all fourth principle. You need to process information rationally, meaning you need to come to a logical conclusion based on the premises you start with. And the second model, associated with James Francis Drane and then the philosophers Dan Brock and Alan Buchanan, argues for a sliding scale. This addresses how closely we look at the rationale for your decision, the level of scrutiny. And it involves 2 axes, or 2 questions. Are you doing what the doctors recommend, or running against the doctor's recommendation? And is it a high-stakes decision or a low-stakes decision? And in cases where it is a low-stakes decision and you're agreeing with the doctor, we don't look that closely. Nobody does a formal assessment of capacity every time you agree to have your blood drawn in the morning. In contrast, in cases where it's a high-stakes decision and you're disagreeing with the medical team, for example, you're turning down an emergency appendectomy, we're still going to use the Applebaum and Grizzo principles, but we're going to look really, really closely. And I will add, just to emphasize, these models are used in conjunction with each other rather than one instead of the other. Advanced directives are the catch-all term for situations in which the patient has specified what they want to do in advance if they lose capacity. And they fall into 2 different categories. There are living wills, which are documents in which the patient spells out what they want done under a given set of circumstances. And the advantage there is specificity. However, it's logically impossible for every possible scenario to be covered in such a document. So the other approach involves appointing a healthcare proxy what in some states is called a healthcare power of attorney or a durable healthcare power of attorney, where you appoint someone else, someone you know and trust, to make decisions for you if you lack capacity. And the advantage of that is you trade off specificity for flexibility. You can have both in most states. You can have a living will that spells out what you want done and a healthcare proxy to make decisions. Since the standard we use to make decisions is what you would have wanted done, chronicity or chronology plays an important role in deciding which trumps if you have both. So, for example, if you have a living will that spells out what you want done in most states, but your healthcare proxy says they discuss the issue afterwards, after you wrote the document, and you change your mind about something, then the healthcare proxy's authority will generally govern in most states. In the absence of that, we would defer to your living will, which specifies what you want done rather clearly. In the absence of an advance directive, which is something where you specify what you want, most but not all states allow a close relative, or in some states, a friend, either of these legally known as a surrogate, to make decisions on the behalf of the patient. I emphasize most states because there now is at least one state, Missouri, that still does not have a surrogacy law. And if you don't appoint someone in advance, the doctors and the courts remain your decision maker. In most cases, the approach the proxy, which is the person you appoint, or the surrogate, the person who is your decision maker by default if you've appointed no one, is supposed to use is substituted judgment. That means they're supposed to do what you would have wanted done under the circumstances if you had capacity. There are exceptions. Those include children or minors, where we use a best interest standard, patients where it's impossible to determine, because we don't have enough information, what their wishes would have been, or if they have no one to speak on their behalf, where we use the best interest standard. And finally, patients who are never capacitated. In other words, patients who, for example, were born with an IQ low enough that they would never have been able to grapple with a decision at hand. And you can look at two cases that address this, and these are the two readings for this week. One is the Sikowitz case from Massachusetts, and the other is the Storer case from New York, both of which deal with never capacitated patients and come to very different conclusions. In the Storer case, the court views it as a bridge too far to ask, if you didn't have a cognitive impairment and had never had one, what would you have wanted done under these circumstances? In contrast, the Sikowitz court uses what a majority of people would want if they did have your capacity, looking on it from the outside. In my article, which is optional reading, which is in the resource section, I talk about how, in general, the Storer approach is probably the better one, but there may be members of isolated, well-defined communities with very clear religious practices, the Amish, Hasidic Jews, where it is possible to predict what a never capacitated person would most likely have wanted, and there it might be worthwhile to defer to their wishes, or defer to their community's wishes. The other question you have to ask in figuring out what a patient would have wanted is, what standard of evidence do you need to use? Do you use a preponderance of the evidence, meaning 51% more likely than not, which is usually the standard in civil cases? Do you use a beyond a reasonable doubt standard, which is usually the standard in criminal cases? Or do you use a clear and convincing evidence standard? And as we'll look next week, in right to die cases, the Supreme Court has said that states can impose a clear and convincing evidence standard, meaning if the family member wants to withdraw you from life support, they need to be able to bring forward clear and convincing evidence that those were your wishes. As we'll see next week, states don't have to impose that limit, but they're allowed to impose that limit. Third-party decision-making is a relatively new phenomenon in medicine over the last 50 years, in part because patient decision-making in general is a relatively new phenomenon. In the 19th century, the only decision when made usually was whether or not to see the doctor. And then once the doctor took control or the hospital took control, they made decisions for you. Doctor knew best. It was the rise of the autonomy model in the 1960s, where patients made their own medical decisions, that then created the necessity for figuring out who would make decisions if patients couldn't make them for themselves. And Louis Kuttner, who you may know from his role in founding Amnesty International, was the first person to propose living wills. At this point, all 50 states honor living wills and healthcare proxies, and there's actually a federal law that strongly encourages them to do so and requires hospitals to discuss living wills and healthcare proxies with patients. In New York State, for those who are interested, forms are actually available on the Department of Health website, though you do not need an official form, to my knowledge, in any state. Most states, including New York, require some kind of witnessing. In New York, it's 2 witnesses. In New York State, for those of you who are in state, you need to make clear your wishes regarding nutrition and hydration, or make clear that the proxy knows them in order for the particular issue of nutrition and hydration to be addressed by a proxy. For those of you in other states who are executing such documents, I strongly encourage you to have your patients, or for that matter, your family members, spell out their wishes regarding nutrition and hydration in case they ever find themselves with this issue in a state where they do require such specification. One of the great conceptual challenges with advanced directives is the concept of bargaining down that you should all be familiar with. Bargaining down is a situation fairly common in many extreme medical decisions, though most of the research has occurred in neurology and the neuro ICU, where patients say in advance, I would never want to live if my quality of life were lowered to a specific circumstance, or I were to find myself in a particular situation. But then when they find themselves in that situation, they say, as bad as this is, or this is not so bad, I do want to live like this. And in some ways, this undermines the concept of advanced directive because it's very hard to predict what you would want in the situation you find yourself in the future. Another dilemma that hospitals have confronted is what has come to be known as the Superman dilemma, after Christopher Reeve, the actor who played Superman and eventually found himself with a C3, C4 spinal fracture and had to live on a respirator, paralyzed for the remainder of his life. And this was a situation where patients would wake up on a ventilator after an accident with a C3, C4 spinal fracture and no prognosis meaningfully of living off a ventilator. And they would say, I don't want to live like this, turn off the ventilator. And this was a conflict between the psychiatry team and the palliative care team historically in hospitals. The psychiatry team would say, give us some time, we can work with this patient, they're in shock, we can treat their depression, their anxiety, whatever psychiatric intervention is causing their distress, and we know that in these situations, half of the patients after a year are glad they didn't turn their ventilator off, and we have data to back that up. And the palliative care team would say, this is existential torture, we're undermining patients' autonomy, maybe we'll give you a week or two, we're certainly not going to give you 6 months to a year. After a week or two, if the patient is still saying they want their ventilator turned off and they have autonomy, we should grant them that right. And this was a debate that went on over and over again in the hospital. Psychiatrists saying 50% of these patients were glad this happened, were glad they were able to live, and 50% of the patients, according to palliative care, regretting that their ventilators were not turned off. I don't have an easy answer to that question. I can tell you that in the United States, for all practical purposes, palliative care has now won this debate. And patients generally are not kept on ventilators against their will for 6 months to a year. And that is a relatively new development of the last 15 to 20 years. I want to share with you a case that is actually repeated to some degree in the questions, but it gives you a sense of one of the dilemmas we often see related to surrogate decision making. So Wilma is a 70-year-old woman who falls on the sidewalk and is brought to the emergency room at her local hospital. In my case, it's Mount Sinai, where I work, where she's discovered to have a fractured femoral neck. She's admitted to the hospital, and the fracture was repaired surgically without complications. However, on day 3 of her admission, she develops bacterial pneumonia. When the medical team attempts to treat her pneumonia with antibiotics, she adamantly refuses. She states, the best treatment for my pneumonia is prayer. Antibiotics won't work. In fact, using antibiotics will show God that I don't have absolute faith and will interfere with the efficacy of my prayers. The woman states that she is a Christian Scientist. Her live-in boyfriend, Fred, confirms this. Shortly after the woman's daughter arrives at the hospital, the daughter insists that you treat her mother. The daughter says, my mother is a lifelong Methodist. She only started going to Christian Science Church 2 months ago, when she moved in with that. She insists that her mother lacks capacity to make decisions and that, as the daughter, she takes priority over the boyfriend. If Wilma lacks capacity, who is the appropriate surrogate? Should you go to court to get an order to treat Wilma with antibiotics over her objections? We will talk about who the appropriate surrogate is in a moment, but I want to address the second question first. Although we've set up general standards for capacity, our society makes an exception for well-established religious communities. So Christian Scientists, for example, doubt the efficacy of medication. They believe that prayer cures illness, and if you accept antibiotics, you're in effect saying to God you don't believe in the efficacy of prayer, and you're less likely to survive. This differs, for example, from Jehovah's Witnesses, who don't question the efficacy of treatment, but question the morality of treatment. Jehovah's Witnesses turn down blood transfusions because they believe that accepting them will lead to consequences in the afterlife, and they violate principles in Leviticus and Acts in the Bible. In a similar way, my parents, who are religious Jews, don't eat lobster because it's not kosher. If you prove to them that lobster tastes good, they're still not going to eat it. It's a moral question. Jehovah's Witnesses turn down blood transfusions for moral reasons. That is different from Christian Scientists, where the woman in this scenario turns down intervention for efficacy reasons. And even though we as allopathic physicians or clinicians in various fields presumably believe to some degree in the efficacy of medication, we as a society defer to Christian Scientists because they have 3,300 churches and a 140-year history and clergy and all of the traditional trappings of organized religion. With that in mind, the question this scenario brings up is the Jello dilemma. You all know the Jello dilemma without knowing it by name. When you were little kids, in my case, my grandmother made Jello. I'm sure you had a relative made Jello for you, colored gelatin. And you would take the tray full of colored water and put it into the refrigerator. And then as a little kid, I would run to the refrigerator and stick my finger in, and it was still water. And then I would go back about 30 seconds later and stick my finger in, and it was still water. And then I would run back 30 seconds later and stick my finger in, and suddenly it was Jello. It was one of those great metaphysical miracles of the universe. When did the Jello become Jello? And it's the same, that's how bioethicists view this dilemma. When does a religious or cultural belief firmly establish itself as a religious or cultural belief? Is 2 months dating a new boyfriend enough? What if the patient was a Methodist until she had a conversation with a patient in the next bed who was a devout Christian Scientist who converted her on the spot? Would that be a long enough held belief? There's no easy answer to this, but this is a question that bioethicists grapple with. I feel obliged to mention the 5 wishes, though I imagine many of you are familiar with them. These are the 5 things one should tell one's healthcare proxy to let them know what one's wishes are. The first wish is the person I want to make care decisions for me when I can't. You should obviously tell your proxy they're your proxy. The second is the kind of medical treatment you want or don't want as a patient. The third is how comfortable you want to be and what trade-offs you're willing to make between comfort and care and life expectancy. Fourth is how you want people to treat you. And 5 is what you want your loved ones to know. Though I will add the caveat, as I think I mentioned last week, that in most states, there are some things that is very difficult to keep from everybody, because most states require you to have a healthcare executor. Unless you're a wealthy patient who can hire a law firm, someone who is involved in your state is going to find out this information. Knowing that, you want to tell that individual what information you do and don't want shared with your other survivors. In talking about surrogacy, those are the laws governing decision-making if you don't execute an advance directive, if you don't either make a living will or appoint a healthcare proxy. I think it's helpful to use a specific example. So New York State uses the Family Healthcare Decisions Act, which was a state law passed in 2010. It was actually the second to last state to enact a surrogacy law. The reason the law took so long to pass, just of interest, is the legislature in New York spent 19 years debating this, and they couldn't agree on 2 different issues. One was how to handle gay partners in the era before gay marriage, and the conclusion they came up with was to give your domestic partner, your civil union mate, or your spouse the same decision-making power, which was in essence kicking the can down the road, because at the time you could have 2 different people, one of whom met either category. For example, a spouse in one state and a civil union mate in another. And the second question was what to do in the extraordinarily rare case of a woman with a viable fetus who was permanently incapacitated on life support, whose husband wanted to withdraw life support and terminate fetal life as a result, and where the woman's wishes in advance were not known. The reason I specify that in great detail is I wrote my master's thesis in public health on that very topic. And I can tell you how many times that rare event has occurred in New York State. And the answer is never. But it took the legislature 19 years of grappling with this non-existent issue before they finally passed the surrogacy law. Their solution, by the way, was not to address it at all. So in New York State, it's important to mention that before this law kicks in, before it applies to the patient, we have to determine they lack capacity. And we have to determine they don't have an advance directive. Because if you don't have an advance if you have an advance directive, then your proxy or living will governs your decision making. And if you have capacity, then you make your own decisions. It also only applies if the patient hasn't left clear and convincing evidence of their wishes independent of some formal advance directive. And I will add, just for those of you in New York and a number of other states, it doesn't apply to patients with MR or severe developmental disabilities, which there are separate set of regulations, basically the never capacitated. 49 states except for Missouri have some version of surrogacy, but it's still preferable to have a formal advance directive. Why? One, you might end up in Missouri, and I actually know of one case where a couple from New York did end up in Missouri, and they did not have an advance directive, and the patient's spouse was not a surrogate for the patient, which they were very distressed by. And also, proxy forms are valid in virtually any country you're going to travel to, or the vast majority of developed nations, while in contrast, surrogacy varies substantially from country to country, and some countries don't have it at all. State surrogacy laws generally have a priority list, so they differ from state to state. In New York State, it is your spouse or domestic partner who is your first ranked decision maker. If nobody fits that category, then we look at adult children, then your parents, then your siblings, and then there's provision for a close friend to make decisions. The only person, incidentally, who can't be your surrogate in New York State is your physician, unless they disavow their role as your physician. But this contrasts to other states. For example, Colorado law asks for a consensus among interested parties. So there's considerable variation in how the states do this. Justice Sandra O'Connor, the former Supreme Court justice, used to say that in matters like this, the federal government should defer to the states because the states can act as a laboratory and they can come up with different ideas and see which ones work best. And particularly with surrogate decision making, we really do have a laboratory of the states where different states have tried very different approaches. I like to ask everybody to think of who their next of kin is, and this is not a trick question, but for healthcare decision making, it is a trick question. Because the terms next of kin and surrogate are often used interchangeably, but in many states they have different meanings. Your surrogate is the person who makes decisions for you, medical decisions, while you are alive, if you don't have an advance directive. In contrast, your next of kin is the person who makes decisions about your body and your property after you're dead. This may seem like one of those obscure points for law school, rather than something the average person needs to know, but in many states the lists are different, because the goal of next of kin law is to pass property from higher generations to lower generations, while the goal of the surrogacy law is to have the person who knows you best make decisions for you. I will add, I know of at least one case, in a high-profile case, where a patient's surrogate collected property from the hospital safe after their demise that should have been collected by the next of kin. And secondly, I like to ask people what a common law spouse is, because most of us who have watched Westerns or mysteries on television are fairly familiar with this concept, but its application in medical law is rather different. So historically, and in some states, your common law spouse is someone you hold out to the public as your spouse for a certain period of time, or just more broadly, depending on the state. So you go to weddings, you go to funerals, you say, this is my wife, they say, that is my husband. Even if you're not formally married, you gain the rights of a spouse as a result of doing that consistently. I always like to add, this has to be consensual, so I can't go to parties and weddings and funerals and tell people I'm married to Queen Elizabeth, and she doesn't tell anybody the same thing, but does not make me king. But if she starts telling people she's married to me, then I wake up one day and I'm king, or at least Prince Consort or whatever I would be, keeping my hopes up. I mention that because in New York State, your common law spouse actually is nothing. They have no more authority than a close friend. But most people don't know that. And there are significant policy implications for this that is worth noting, because it means that well-off people can often get all the benefits of marriage without any of the detriments. They can set up healthcare proxy forms and trust fund forms and work with a white shoe law firm to make sure that exactly the rights they want transferred to their partner, often their second partner, are acquired, and none that they don't want. And they tell people they're married when they're actually not. You'd actually be surprised how many upper middle class couples that you think are in their second marriage are actually not legally married, though they tell people they're husband and wife, for tax and legal purposes. However, if you are a low-income person, do not have a lot of social capital, you may not know any of this, and you may think common law marriage actually is marriage. And I see this every week at the hospital. You think it's a legal right, and then you show up at the hospital in New York, and I ask you what your relationship is to the patient, and you say they're my common law spouse or my common law wife or common law husband, and suddenly discover that you don't have any decision-making power, and the patient's estranged sibling in Wyoming is actually their decision maker. And I mention that because sometimes the perception of what the law is can actually have very significant implications for patients, even when it's not the law itself. Surrogates generally have immunity for good faith decisions under the statutes in each state, and proxies as well. So as long as you're acting in good faith, you can't be held liable for the decisions you make. I mention that in part because often when I call up a surrogate or proxy who doesn't know they're a surrogate or proxy, they get very nervous and they say, I didn't know I was the proxy. I'm going to consult a lawyer to make sure I don't have any legal obligations. Once, in a case I will never forget, we arranged at great length to reach out to the patient's cousins in a foreign country and used a translator, and there were time zones involved. And I finally got through to them, and I said something to the effect of, "Your cousin Fred is in a very bad way, and you're his decision maker. What do you want done?" And the person who was the right person at the other end of the phone said in shock, "I have a cousin Fred. So you really want to talk this over with your decision maker." States vary significantly on how much effort must be made to track down a surrogate or proxy. And I actually recently published a paper on this very subject, which I've included entirely as optional reading in the resource section. But it is a good example of the kind of paper one might write for the final paper, choosing a particular area and looking at various state laws on the subject. And then states vary significantly on how much effort must be made to confirm the identity of a surrogate or proxy. In New York State, for what it's worth, both of these questions require a diligent effort, which is much more than most things the law requires, which is just a reasonable effort. I will finally tell you a rather unsettling story from my own hospital experience from many years ago. A patient had come to the hospital and he was suffering from moderate dementia, and the social work team felt he needed to go to a nursing home, but his adult son, who was with him, adamantly objected and said he could care for the patient at home. When they asked the patient what he wanted, he looked around and said, "I don't know any of you, leave me alone." 2 weeks later, the patient's adult daughter showed up at the hospital and revealed the patient did not have an adult son. She was a member of the community who had moved into the patient's home and was cashing the patient's check. So if you say to me, "This is my wife," we shouldn't demand a marriage license and make sure you prove it's your wife. But if you don't tell me this is your wife, we shouldn't necessarily take her word for it. We may want to do a little bit more digging, particularly in a high stakes case. I mentioned the issue of nutrition and hydration, and oral nutrition and hydration is generally not considered healthcare by the courts in New York State or in most states. So the FHCDA, the Family Healthcare Decisions Act, has special rules. And basically, a surrogate can only ask for removal of nutrition and hydration in specific circumstances. If the patient is terminally ill with less than 6 months to live, if the patient is permanently unconscious, or in the case of irreversible suffering, either emotional or physical. Obviously, this covers the vast majority of cases. The rules will differ slightly from state to state. You should not necessarily memorize the New York standard. You should understand that different states have different standards regarding when artificial nutrition and hydration can be withdrawn. In the absence of any decision maker at all, the law in most states is that physicians may provide routine medical treatment, such as medication, physical examinations, blood tests, except for psychiatric medications in most states. But that two physicians must agree to provide major medical treatment, such as surgery. I will discuss a particular loophole in New York state law that is relevant for the larger issue of why it's important to have a proxy and not just a surrogate. So one reason you might want to have a proxy form rather than simply defaulting to surrogate decision making. Um, and an example where that might come up is, let's say I come to you as a patient and you tell me, you should really have a proxy form. And I say, "Doc, I hear what you're saying, but I know that if I don't have a proxy form, I don't appoint a proxy, then my surrogate is automatically my decision maker. And for me, they're the same person. But my wife would be my proxy, and without a form, she's my surrogate. And if I made a form, my backup would be my only son, my adult son. And without one, my surrogate would be my adult son. Why waste time with a form?" So I mentioned earlier there was the issue of jurisdiction, of making sure you have something that is valid in every state. I will add that most doctors understand what a healthcare proxy is, but the concept of surrogacy is fairly new in many states. And if you go to some small community hospital and you tell them you're the patient's surrogate, they may think you're just dating the patient's baby. They may not really understand the concept. Um, but in New York State and a number of other states, there are other loopholes, and I will just give you an example of one. So in New York State, if you have the patient's healthcare proxy and the patient lacks capacity but wants to turn down an elective procedure, you can still overrule them and authorize the procedure. So a patient comes in from a nursing home, they need elective cardiac surgery to reduce chest pain, not emergent, but you're their appointed healthcare proxy and they lack capacity, you can authorize the surgeons to do that. In contrast, in New York State, if you don't have a proxy, if you're just the surrogate, the default decision maker, and the patient is objecting, even though they lack capacity, you can't override them without a court order. And the reality is that patient is unlikely to have that surgery because no cardiac surgeon wants to go to court and testify on that patient's behalf and lose a half day of work in the hospital. This is actually a considerable source of tension in New York State and a number of other states. In most states, including New York, any person on the surrogacy list can challenge the appointment of a surrogate. And for that matter, in most states, the patient can challenge the appointment of a surrogate. And then hospitals have different approaches. In New York and the majority of states that address this, the decision is reviewed by a hospital ethics committee, though eventually it may end up in court. Um, in general, surrogates and proxies must have capacity to make decisions on their own, and they must be acting in good faith. And if they're not acting in good faith, the physician can generally turn to the next surrogate or proxy available on the list, although this is rarely done. I want to emphasize that bad faith is not the same thing as bad judgment. So often patients, surrogates, or proxies will make bad choices, and often they actually reflect the preferences of the individual patients that might have been bad choices. It's self-dealing or overriding the patient's wishes or interests for one's own personal interest, acting in a non-fiduciary manner. That kind of bad faith is the level that one needs in order for someone to step in and abrogate the surrogate's or proxy's authority. In general, hospitals and physicians assume good faith and assume the relationship between patient and surrogate or proxy, barring concrete evidence to the contrary. Another area where there's a significant difference among the states, and this is really a great example of O'Connor's laboratory of the states, is what happens if there's conflict among the surrogate decision makers. So what happens if the patient lacks capacity and needs a high-stakes decision made, and the patient has 3 sisters, all of whom would equally be the surrogate, and they don't agree about what the patient wanted? So some states require a majority vote. One state, West Virginia, actually offers the physician to choose among the competing claims based on what he or she thinks his perception of what the patient would have wanted would be or what is most reasonable. In Maryland, non-hospitalized patients can require unanimity among the surrogates before any kind of care can be withdrawn. In New York State, an ethics committee, not the court, is generally the arbiter of the surrogate in these circumstances. And now I want to talk a bit about psychiatric advance directives. Psychiatric advance directives are advance directives in which a patient with a psychiatric illness, when they have capacity, when they are able to make decisions, specifies what treatment they want or don't want once they lose capacity to make those decisions. These are often known as Ulysses contracts, after Ulysses, which is the Latin name for Odysseus, the character in the Odyssey, after Odysseus' encounter with the sirens. You may remember from the Odyssey that Odysseus wants to hear the beautiful sound of the sirens, but he knows that if you get too close to them, you crash on their rocks and they kill you. And they have this beautiful, attractive music. So he tells his sailors, put beeswax in your ears so you can't hear the sound, and then bind me to the mast. But don't put wax in my ears, so I'll be able to hear the sound while we sail by. And I will beg you, I will indicate to you that I want to be untied so I can get closer. Don't listen to me. Don't untie me. In essence, Odysseus is binding himself to a future situation. That is the Ulysses contract. And in a psychiatric advance directive, a patient is binding him or herself to a future situation. They're saying, once I lack capacity, if I've said I don't want a particular treatment, don't give me that treatment, even if that lack of treatment keeps me from regaining capacity. So, for example, my hospital still does not honor psychiatric advance directives. Their legal status in New York remains highly ambiguous, though some states do honor them. An extreme case of this was the case of Nancy Hargrave, who was a woman with paranoid schizophrenia in Vermont, and 4 past psychiatric hospitalizations, who was in the state hospital at Waterbury. Prior to her admission, she created a psychiatric advance directive, and a fairly airtight one, in that she had a forensic psychiatrist, as I recall, evaluate her before she did it to demonstrate she had capacity, and I believe a lawyer draft the document, saying that if she were hospitalized again, she did not want medication. She'd be willing to remain in the hospital forever if she had to, where she wouldn't be a threat to herself or others. But if she were a threat to others outside the hospital if unmedicated, she said she'd rather be hospitalized than be medicated. I should emphasize she's not malingering. She's not looking for a place to stay. She would actually prefer to be released, but understand she might be a threat to the public. But she found the medications made her so much not herself that she couldn't tolerate them. And the question arose, which is a court question, should the courts honor Nancy Hargrave's psychiatric advance directive, which was in essence a Ulysses contract that could have kept her in the state hospital forever? And the federal courts actually upheld Ms. Hargrave's psychiatric advance directive, and allowed her to stay in the hospital unmedicated. The courts have ruled that states do not have to permit advance directives but once they do, they can't discriminate between physical advance directives for physical illness and mental illness and psychiatric advance directives, though no New York State court has actually ruled on this yet. It's unclear whether or not this would have a significant financial implication for the mental health system, because on the one hand, you might think that keeping a patient in the hospital indefinitely was not cost effective, but readmitting a patient over and over again when they go off their medication is actually also very costly. So there's no good economic data on whether or not this is a wash or actually costs more money. That is the end of the introduction to third-party decision-making for week 6. I will attempt to have a discussion forum later in the week or next weekend, and we can discuss the cases further. Thank you.